7:30. Welcome back to Sunrise Daily. Well, we start off today, yes, indeed, where we left off. Constitutional amendment. Do remember that the House of Reps have gone on to effect some amendments which some had deemed controversial. Let's give you this report, a roundup of what happened on the day.
After the false start of the day before, everything appeared finally set for electronic vote on the review of the Constitution.
Be guided by the wishes and aspirations of our constituents. I have mine here, and I will be guided by it. Please let us all be guided by that.
But 3 hours later, the electronic system could still not be used for voting. The lawmakers then opted for manual voting. In almost examination mode, the lawmakers began the voting process. While some remained on their seats, others sat together as a group, according to their states. An hour later, collating began. It's been 3 hours now since the collation began, and the lawmakers have been here. Some have walked out, walked back in. The Muslim lawmakers have even had their prayers here. They've said their prayers here, and even those fasting have broken their fast in the chamber. It appears there's a determination on the part of the lawmakers to ensure that they wait this out and get the results before they leave plenary today. 5 more hours passed before the results were announced.
Clause 1. All the 339 members participated in the voting. The ayes, 293. The nays, 39. And 7 abstained.
Thank you very much, Clerk.
Thank you, Mr. Speaker. May I move that the House reverts to plenary?
The voting on all the clauses that we have had before us this morning, clauses 1 to 87, and from the report of the Committee of the Whole, which was earlier on read out, and the result of the voting, which was earlier on read out by the clerk, none of the clauses failed. All of them have met the mandatory requirement of 2/3 for them to be passed by the House of Representatives.
The lawmakers say more amendments to the 1999 Constitution will still be considered by the House after the return from recess. Lanre Lasese, Channels Television News.
All right, and to discuss that event, what happened on the floor of the House of Representatives on the day, we're joined from our Abuja studios by Emmanuel Anyigbunam, who is a legal practitioner and a public affairs analyst. Morning, and thank you for joining us today. Well, yes, indeed, you've heard the House of Reps voting, meeting up with the 2/3 majority requirements for any of those amendments to sail through. Immunity clause, one of the very controversial ones for presidents, vice president, governors, deputies, voted out, removed, and then, of course, you have a lot more, but one step at a time. What's your thoughts on this one? Did you see this coming, by the way?
Well, the issue is that we have to be guided by the general principle and best practices of constitutional amendments. In constitutional theory, the Constitution can only lay a framework of law and order. It cannot solve specific problems directly. We must bear this in mind. And in coming to this tone, the Constitution is the ground norm and handwork of the people, while lawmaking is the handwork of the legislature. If you take a good look at our general amendment section in the Constitution, section 9.2, you will see that it is tilted more to lawmaking procedure, which we have always argued that there would have been a room for basic referendum. But be that as it may, it is our law and we have been on to go with it. So coming to the immunity clause which you have raised, yes, the aim of immunity clause is to keep chief executives without distraction whatsoever in the performance of their duty. That is, in executing the laws made by the various tiers of legislature for order, peace, and good governance of the country within their specific jurisdictions. But we now notice that after a time, this immunity clause has been converted into or transformed into an engine of fraud by public officers who now, by the appalling abuse of office and corruption, which we have noticed since 1999, it now led to the call that let us remove this immunity call, that whoever is a government, whoever is a chief executive can now face more of criminal prosecution if he goes out of the law, because we've seen. But meanwhile, like I have said, will this be an issue for constitutional amendment? When you take the view that those who have left office, who were chief executive, especially the governors, who were charged to court, after barely 10 years, you have seen that none of those cases have really gone anywhere. And the issue that says before all of us was that of Ibori. You know that Ibori was even in charge to court. From Kaduna, he more or less diplomatically, a federal high court was established in Asaba, and where he was given a clean bill of health until he went to Britain, and we saw what happened. So what I'm saying is that apart from constitutional amendment or talking of immunity, those governors and chief executives who have faced trial since then, have you even been able to do that within the confines of the Constitution? Then if you amend the Constitution, will there be a change of heart? And I have said that our problem is not basically in constitutional amendment. We're taking the issue of the governors, 5 governors of Bayelsa, Kogi, Adamawa, Delta, and Cross River State. You amended the Constitution saying that whoever took oath of office, if you are re-elected, that your tenure starts from the first oath of office you've taken. We were here where they stayed almost 18 months and had a free will until the Supreme Court now said, now we are going back to the first. So my take on this is that the Constitution is the ground norm, but the attitude of the people and practitioners will make the Constitution a success or a failure. So based on this, my submission is that yes, you may need to amend the Constitution, but after amending the Constitution, your environmental factors or political unwillingness to sanction and punish evil may even not be an advantage of what you have thought. So that is my submission on that.
Well, anyway, if you look at it critically, perhaps maybe we should break it down to get to your point here, because people are already divided on this. Some say even when they leave office, when they do leave office, as you highlighted, well, we still don't have the political will to bring such persons to book, as if they have what you would want to call perpetual immunity clause hanging over their heads. So what exactly do you think is lacking to the extent that people are calling for the removal, while others have argued that it should remain?
Well, the issue is this, like if you remember our former Chief Justice of the Federation, Alpha Belgore, he was one of the first prominent voices who said that now it is better to remove this to enable those, because you will consider a lot of things in a criminal process we have in the country. The freshness of a case will enable you to prosecute and then have the basic effect. If you wait so long until the person leaves office, he may distort or even have a lot of influences on the procedure, and then some of the witnesses may have left office as well with him. So the issue is that, it's like I have said, we may decide to remove immunity clause and then now let them face criminal charges. Like what I'm saying is that the civil immunity may remain. But when you are found